Can a beneficiary be a successor trustee? Have you ever wondered if a beneficiary can also take on the role of a successor trustee? This is an important question in estate planning that many people ask. The good news is that yes, a beneficiary can legally be named as a successor trustee of a trust. This arrangement is quite common. Often, the individuals who will receive the trust property after the settlor's death are also appointed to manage the trust as successor trustees when the original trustee can no longer serve. Why would someone choose a beneficiary as a successor trustee? The primary reason is trust. The settlor typically believes that the beneficiary will manage the trust assets responsibly and carry out the terms of the trust faithfully. This dual role can simplify the administration of the trust. The successor trustee has a direct interest in the trust property and understands the needs of the other beneficiaries. However, there are some important factors to consider. One major concern is the potential for conflicts of interest. When a successor trustee is also a beneficiary, especially in cases with multiple beneficiaries, it can create challenges. The trustee must act in the best interest of all beneficiaries, which can be tricky if their personal interests are involved. Another consideration is the number of successor trustees. Some trusts name a single successor trustee to avoid conflicts, while others may choose multiple co-successor trustees. While having co-trustees can promote fairness, it may also lead to disagreements, especially if the trust involves long-term management of property for younger beneficiaries. The qualifications for a successor trustee are also important. They must be at least 18 years old, of sound mind, and typically a citizen of the United States to avoid tax complications. Even if a beneficiary meets these criteria, they may not want to take on the responsibilities that come with being a trustee. Additionally, many trusts include alternate successor trustees. This is a smart move in case the primary successor trustee is unable or unwilling to serve. From the perspective of elder law and estate law, naming a beneficiary as a successor trustee can be practical and efficient. However, it is essential to think carefully about the relationships among beneficiaries and the complexity of the trust assets. This helps minimize disputes and ensures smooth administration. Consulting with an estate planning attorney can be a wise step to tailor the successor trustee appointment to the specific needs of the trust and its beneficiaries.